Good afternoon and welcome to a practical guide to regulatory investigations and inquest webinar. Please note, if you would like to submit a question during this webinar, please click on the Q&A icon, which you'll find on the bottom right corner of your screen. All questions that are submitted are anonymous to other attendees, and only the panelists will be able to see who submitted a question. Please also note that this session is being recorded. I will now hand you over to Jonathan Taylor.
Thank you, Becky, and welcome in, everyone. I hope you're well. Just wanted to introduce myself, Innovation, and the guys at Beechcrofts. First of all, thank you very much in advance to the guys at Beechcroft for supporting us on this particular event. So we're very lucky to have Tom Walshaw, Nicola Johnson, and Anna Hart. All three have got plenty of experience in regulation, civil claims and inquests. So thank you very much, guys, for your support on this event. So this event has come from feedback from a number of clients and people in the sector. So we are seeing a big increase in the amount of inquests and sort of regulatory investigations in the sector. We thought it'd be helpful for clients to be in a safe environment and see what's coming over the hill and take away some practical advice they can utilise in the future. I noticed from some of the names that are already registered for today's event, some of you have been through inquests in the past, and I know some, in fact, are going through quite complex inquests at the moment. So hopefully this is timely and will offer some additional support for you. So as Becky said, we are going to mute everyone apart from each speaker, just to avoid any children, dogs or any strays coming in while we're talking. So there is a Q&A box, should be in the bottom right. So please do type any questions as you go along. It won't interrupt us, so feel free to fire them along. And then what we will do, we'll have a Q&A session at the end, and we will try and answer every single one of those questions. If we do run out of time or we're lucky enough to have too many questions, we'll follow that up with a Word document which will circulate in the coming days. Just for the benefit of some of the guys that are attending that aren't aware who Innovation are, just want to give you a very quick introduction to us. So I'm Jonathan Taylor, Director of Innovation, and I head up our Charity and Care division from our London office. So we're very much specialist in charity and care. So some of the clients we look after are on your screen in front of you now. So this event is part of a series of events. I think we're on our webinar number 6 since lockdown. So we've very much put our head above the parapet and try and offer as much additional support as we can. We have got a few more events coming up in the coming months before the end of the year, so we'll keep you posted on those as well. So I'm going to pass over shortly to one of our colleagues at Beechcroft, and then I'll be coming back in later on just to talk about the insurance implications regarding inquests. But just to set the scene in terms of the agenda for today, so Nicola and Anna are going to talk through a bit about setting the scene in terms of inquests and regulatory investigations, and talk about that immediate aftermath. So something's happened. What do you do? You're in the panic stations. For some of you, you might not have had an inquest before in the past, or it might be your first one for a long time. Then Anna's going to talk a bit about the regulators, and Anna and I were talking just before we started this webinar, and she said that the regulators are ramping up their activity. Now they're getting back to some sort of new normal. Nicola's going to talk us through sort of the inquest process, and then Tom's going to close off that section talking about how civil claims can arise off the back of any of these processes. And then I'll close the session talking about how your insurance policy could respond to support you, and try and offer you some practical tips. I'll also try and give you a very quick overview of what's going on in the care world in terms of insurance at the moment, as I'm sure that's something high on the agenda for some of you. So without further ado, I'm going to pass you over to Nicola. She's going to kick off and talk to you a little bit about setting the scene. So I'm just going to pass over to Nicola now.
Talk about the initial stages following an incident. My name is Nicola Johnston. I'm a lawyer in the Specialist Liability team at DAC Beechcroft in London, and thank you all for joining us today. So I'm going to talk to you about what you should do following the death of a service user in your care, and a bit about the inquest process. So to make today a little bit more practical, I'd like you to imagine a scenario. You're the manager of a residential care home called Brightside, providing care for the elderly. There's a lovely resident in your care home. She's called Jenny. She's 80 years old. She suffers from dementia. She has mobility issues and a very severe nut allergy. You can probably guess where this is going. She needs assistance with all aspects of daily living and particularly care with regards to eating. You employ a carer called Barbara, and she's allocated to Jenny's care. And on the 1st of September this year, as if this year couldn't get any worse, she goes to the kitchen to retrieve Jenny's lunch. She comes back and she spends about 5 minutes assisting Jenny with her meal when she notices that Jenny is starting to struggle with her breathing. She goes to the kitchen to retrieve a bowl for Jenny to split her food into, and when she comes back, she finds that she's collapsed on the floor. She calls an ambulance, and sadly, Jenny dies at hospital. So, what are the first steps that you need to take following this incident? Taking a step back, I hope that you have a disaster and crisis plan in place. This will ensure that everybody knows what they need to do and when. It's going to be a really stressful time for everyone, and so the plan should be in place, which can be referred to if necessary. You're going to need to notify the designated safeguarding lead and an appropriate manager from the home. Someone needs to be appointed to coordinate the response. Of course, the next of kin needs to be notified, and this is in a healthcare setting, so the statutory duty of candour applies, and this requires you to be open and honest with the family from the outset. If you don't know what happened, you need to tell them you don't know what happened and that you're investigating and that you'll keep them informed. You need to complete an instant report form. This needs to be clear and detailed and include details of witnesses. It needs to be signed and dated. And I've seen many an instant report form, not necessarily in the fatal incident, which has been so poorly drafted that claims that materialise later have had to be settled because we've been unable to investigate them. You're going to need to obtain witness statements from all of those who were involved in Jenny's care, and we'll talk more about that in a moment. And you need to notify the appropriate regulator. So in this case, that's the Care Quality Commission, the CQC, because we're in a healthcare setting. But if the death had happened to an employee, you'd need to notify the Health and Safety Executive by way of RIDDOR report. And if the incident had taken place in a school, you'd need to notify Ofsted. Now, Jenny was a vulnerable adult, so in accordance with the Care Act 2014, the local authority needs to be notified so it can consider whether or not to commence a safeguarding investigation. And the same is true if it had happened to a vulnerable child. You'll then need to commence your internal investigation, and we'll come on to that in more detail shortly. And finally, you need to notify your insurers. They may be able to arrange solicitor representation to assist you with a regulatory investigation and any inquest. And a failure to notify them may result in cover being declined should a claim materialise at a later date. And if you read the small print of your policy wording, you'll see that there is a requirement that you notify them as early as you can following an incident. Sorry, moving on to the next slide. So the internal investigation is a vital tool for improving safety. And the more thorough the investigation, the less likely the regulator or the coroner is to criticise you or your organisation. It must be conducted honestly, and the statutory duty of candour, again, in healthcare settings requires this, and there are very serious penalties if it is not. You must remember that the report and all of the documents which inform it will be disclosable to the coroner, the regulator, possibly the police, and the deceased's family. There are some circumstances where documents can be withheld from disclosure, and that is if they are prepared for the dominant purpose of litigation. And that's unlikely at this stage because, of course, we're in the immediate aftermath. I really recommend that you avoid emotion and opinion in all of the documents that are generated after an incident. By way of example, I've recently handled an inquest for a care home following the death of a resident, where the manager of the home had written several times in the investigation report that the carer involved had been grossly negligent and incompetent. Now that may be true, but that's an opinion. Much better to stick to simple and clear facts. What happened? When did it happen? How did it happen? Why did it happen? What should have happened and why didn't it? And really importantly, and perhaps most importantly, what are you going to do to ensure that a similar incident doesn't happen again? Can you evidence the steps that you have taken to avoid a recurrence? A poor investigation report can damage reputation, and it can increase the likelihood of adverse action being taken from regulators and the coroner. I'm going to pass over to Anna now, who will talk more about the internal investigation.
Lovely, thanks, Nicola. So in terms of the internal investigation, and Nicola's given you some heads up there in terms of the points to cover, but in detail, what is that process going to require you to do, and where do you start in effect? I know a number of clients have said to me in the past that it's quite an overwhelming job to know where to start and how to make some sort of system into as part of the process, and how to get to the point where you've got some distinct recommendations and conclusions that have some real meaning and action attached to them. So the first place I think to start is to look at the records for the individual concerned, to try and understand their background, and that can obviously vary hugely depending on whether or not this is a service user that you know well. You could have had them in your service for many, many years, or it could be somebody who's been in literally for a couple of days, but you need to establish that and understand what we know about them, what it was reasonable for the staff to have known, and what your starting point is in terms of understanding the level of care that was being provided. It's always then sensible to break down the incident into a timeline. We find this can be really helpful in terms of your own understanding, but also when it comes to explaining it to external stakeholders, whether that's the coroner, a regulator, or indeed the family. Keeping it very factual at first can really help to then create the skeleton, if you like, that you then flesh out as the investigation goes on. It will be necessary to interview staff. That can be difficult for a number of reasons. If there's a regulator involved, particularly if it's the police, if there's been a fatality, you may actually at this stage be told you're not allowed to speak to the staff, or there's a limit to which staff you can and you can't speak to. If there is a regulator involved, it's really important that you check that point before you start speaking to staff members, because it can be detrimental to the external investigation, which sets you off on a difficult footing, which can be hard to recover from. But even if you can interview staff and there's no external regulator involved, you can expect your staff to be emotional and upset and confused about what has happened. Although they are accustomed to working in a social care or education setting, it's unlikely that they've really anticipated that this sort of unexpected death is something that they would encounter as part of their job, or certainly as a regular part of their job, and they're undoubtedly going to find it difficult, particularly if it's a service user that they know well. So actually sitting them down and getting to the hard facts of what happened, what were you doing, why did that happen, what was the policy you were following, what was in the care records, can be tough, and it needs a real amount of empathy and sensitivity to make sure you can get the best information that is available, because this is the time to get that best information when it's fresh in everybody's mind. I've been looking at an RCA report myself this morning for a client and found that there are some gaps in the evidence that was obtained, and now 11 months down the line I'm looking at that thinking I'm not sure that we're going to be able to fill those gaps because staff have left, or they've lost their memory of what has happened, or they're just reluctant to talk about it again. So to try and persist at that point to make sure that you can get as much information from staff, and as many staff as you possibly can at that point. And when you're doing those interviews, again, distill it into a written statement, even if that is in fairly rough form. I mean, as lawyers, we will always say there's a set format that you should use. A Section 9 witness statement is a term that's often used. But in reality, as long as you've got it recorded in writing and it's signed and dated by the person whose evidence it is, then that carries some value going forward and is something that we can rely on for future. So if you have the luxury of time and space to be able to use a template witness statement within your organisation, fantastic. But if you haven't, please do still write it down in whatever format you can and get it agreed by the member of staff you're speaking to as their evidence, should it be needed later. When you're looking at the report, have a look at whether there are any other documents reports, previous incident reports, medical reports, etc., that might be of interest and help to understand the context of what has happened. And then think about what other evidence you might need to fill in the gaps in terms of what happened on that particular incident. And that's likely to be the corporate policies, procedures, guidelines to set up what was meant to happen in this situation, because that is your starting point in terms of understanding what was the expectation, at least in theory, and how does the reality of what you've gathered through your witness statements and your core documents compare to that? Is it an exact replica, in which case it's unlikely that you've got any cause for concern, or is it, what's far more likely, a working interpretation of that policy, procedure and guidance which has required a degree of pragmatism and application into the real world, and then some analysis of how far the variation goes. But you do need that policy and procedure as a starting point in terms of what the company expectation was. And it might, of course, be as part of your investigation that you find that it's those documents that are part of the problem, and that's something that you should be thinking about in your internal investigation as well. And then, of course, risk assessments and care plans and other medical or care records for the individual, which again help you to understand the minutiae of what happened on any given period, whether or not this was a genuine, isolated one-off incident, or perhaps what you need to be thinking about is actually, is this part of a chain of events or a repeated breach, or in other words, an accident that was waiting to happen. From a cynical perspective, is this something that could have happened a while ago, but it happens to be now, but actually the standard of care hasn't been great for a while, in which case that still needs to be acknowledged within the internal investigation. So once you've gathered all of that evidence and you've got in your report a timeline of facts and a narrative of what happened, then comes the hard bit in terms of crunching that into some findings and conclusions as to evaluating what happened and understanding what was good, what was bad, and where you can learn lessons and make improvements for the future. This slide sets out the whole list of factors that you might want to consider. They won't all be relevant every time, but I think it's a really useful starting point to think through the types of things you should be looking at, some of which are more obvious than others. But bearing in mind, if we're talking about a root cause report, root cause analysis, it's looking beyond the immediate and the obvious to think about, well, why did that happen, and what was the cause of that, and where was the real start of this problem? And that could be something to do with the patient or the service user in terms of their behaviour and our understanding of their behaviour. It could be to do with individual staff members in terms of their level of training and understanding, but also in their behaviour and whether or not they were complying with policy and procedure. If they weren't, was there a reason for that? Is it a reason that they need to take responsibility for, or actually is it more of a systemic issue that, again, the organisation needs to think about, well, how and why did that individual feel the need to behave in the way that they did? And then a whole host of other things, task factors. What was it reasonable for them to be doing what they were doing under the conditions that they were? Were they communicating effectively? Had they been given enough information to know what was expected of them? Did they have the equipment and resources available that they needed? You know, quite often we come against cases where, for example, if there has been a fall in a care home, then it may be that actually the manual handling equipment has been there in a long time, that hasn't been reviewed, and perhaps it has been defective, or it's unreliable, and therefore the staff have stopped using it because they don't have faith in it. So actually the incident might have had nothing to do with equipment, but the point is that they weren't using it because they didn't like using it, they found it cumbersome, it was inconvenient, the patients didn't like it, all of those sorts of issues that might come into play. And then I think more fundamental issues around organisational and strategic factors. So this is more around the sort of policy and procedure level. Is there something more fundamental of concern in terms of perhaps your staffing numbers, your supervision arrangements, the way in which your services are set up that make it difficult for staff to do the job that you've asked them to do? And that's where you need to think really quite long and hard, because if there are those organisational and systemic issues, then they could be an indicator of actually a much bigger problem, and one that needs to have some multi-level learning, both in terms of this specific incident, but also to ensure that similar incidents don't happen again in future, which is a really important output of an internal investigation. And then when you've got to the point of having your list of findings, it's really, really important to give some thought to which of those findings are causative of the specific incident or contributory factors and which aren't. They're all very, very valuable, so you must not discount something because it's not causative of this particular incident. Certainly for the purposes of an inquest, the coroner may well still be interested in other factors because they may well give rise to understanding the risk of a similar incident occurring again in future. And regulators will always be interested in those other factors. But in terms of defining potential liability and understanding how this particular incident happened, we do need to be very careful that we give a good analysis to what was the actual cause and what wasn't, because that could make a real difference both in terms of any criminal liability at the hands of any regulator, but also a claims issue as well. And if you're not sure on that, then it's worth pausing at that point to really get some advice and to think about it either as a board group or seek external support if you absolutely need to. But again, so many times we've seen RCA reports which are great, but when it comes to understanding what happened, it becomes a bit of a jumbled mix of not really understanding what was causative and what wasn't. And of course that in itself can be an indicator that you haven't really fully understood what happened and why it happened, which could be a cause of concern for both the regulator and the coroner in due course. And then, of course, coming out of all of this is the sort of tangible actions. So you know what's happened, you know why it's happened. We now need to think about, well, what are we going to do about it to make sure that a similar incident can't happen again, or that we can improve our standard of care and support that we're offering. And in many respects, this is one of the most important parts of the report because, again, from both a regulatory and a coronial perspective, a key question is to understand the risk of similar incidents occurring again and whether or not there is a need to cajole or push the provider into taking action that it hadn't otherwise considered itself. So if you can show as part of your RCA report or internal investigation that you've identified some recommendations, you've done them or you've set out to do them, then that really takes that issue away from both the regulator and the coroner, which can really improve how those formal proceedings might go and the extent to which you need to be involved in them. So if you're going to make some recommendations, they need to be meaningful, so they need to be linked to your conclusions. It needs to be clear what they're intending to do, so what is the issue that they are addressing. And we need to be as accurate and accountable as they can, so this SMART acronym that many of you will be very familiar with, to be specific, measurable, achievable, realistic and timed. External stakeholders will want to know how you're progressing against them, so the smarter your recommendations are, the easier it will be for you to demonstrate how you're doing and how you've eventually ticked them off, if you like, or turned them green on your action plan to show that the action has been completed. Many actions will take a while to complete, or you will have a range of longevity in terms of how long things take, and that's probably a good thing to have some immediate quick fixes, some of the things that would be much more strategic and take a while to get sorted. But where you can demonstrate that you've prioritised those actions and dealt with quick fixes where you can, but put in interim measures to manage longer term concerns, and that's really important and demonstrates that you are on top of the risk, you understand it, and you are taking a sensible and sensitive approach to ensuring that your other service users and patients are being cared for as adequately as you possibly can, even whilst you're unpicking difficult situations. That's very, very important. And then I think finally on this one, it's about making sure that once you put these actions in place, you're going to sustain them by reviewing and auditing progress. Again, I've seen too many cases to remember where there's an action plan from perhaps 2-3 years ago which identifies an issue of concern. There was a flurry of activity at the beginning and then not very much. And in fact, I've got an inquest coming up in a few weeks where it's taken a long time to get to inquest stage. It's going to be just over 3 years, I think, by the time we hear the hearing. And I'm dealing with this exact issue at the minute. Is we've got an action plan that back in the autumn of 2017 looked really busy and lots was happening and lots of training was being rolled out and improvements and staff awareness and new policies. But actually now that we're in the autumn of 2020, I'm having to say to this particular client, how do we know that that stuff is still effective? How has it moved on? Where have you developed? and making sure that it didn't just hit a hiatus point and sort of stopped and stalled. So it's really important that we can show that whatever recommendations we've got are sustainable, bearing in mind that you may find yourself still talking to them sometime later, given the time that it can take to get through the inquest and regulatory process. And then the final point on this slide is just about embedding that learning. Embedding of improvement is a particular area of interest for CQC at the moment. So for those of you who are in registered health and social care, we see a huge number of inspection reports or enforcement action that talks about having evidence of embedded improvement. So it's not just that you've done it, it's that you are making it part and parcel of what you do on a day-to-day basis. And again, this point of it being sustained. So making sure that whatever you do is fully taken on board by your staff and becomes part of their everyday working lives is really, really important. And that's not just left to chance. Just going to pass it back over to Nicola now, who's going to pick up with witness statements.
Assuming the regulator allows you to talk to your staff, you're going to want to obtain a witness statement from them in the course of the investigation. And the witness statement is essential to any investigation and should always be taken following a serious incident. And you need to remember that it will be disclosable. So a statement from Barbara is going to be crucial. She was closest to Jenny in space and time, and it may be that something that she did or omitted to do either caused or contributed to her death. But as Anna has alluded to, you're going to have to handle her really sensitively. Barbara's going to be very upset and possibly in line for a disciplinary conduct meeting. She needs to be handled really sensitively. So talking about the inquest that I recently handled, I can only imagine how the carer felt in that case, being directly accused of incompetence and gross negligence. It's unlikely that she was willing to cooperate, and of course you really do want the witnesses to be on side. You'll also want statements from any other employees or workers who were involved in Jenny's care, particularly anyone who worked in the kitchen. How was it that Jenny's food became contaminated with nuts? Why wasn't it labelled appropriately and separated? Was the risk assessment and care plan followed? Why did Barbara go and fetch a bowl from the kitchen to enable Jenny to spit into it? How long was she gone for? Statement is also going to be required from you as a manager to explain the procedures and the policies that were in place. You want to know about what the policies and procedures were for feeding residents, and particularly those with food allergies. What should have happened and what went wrong? And again, back to my earlier point, really try to avoid opinion and emotion and stick to the facts. A comprehensive witness statement at this stage may avoid a later attendance before the coroner. And I'm going to pass back to Anna now, who will talk about how the regulator is likely to respond to this incident.
Thanks, Nicola. So in terms of the regulator, I think it's worth taking a step back at this point to understand the order in which matters would unfold in the circumstances that we've described in our example. The coroner will be informed immediately, will open his inquest, but will most likely adjourn it to allow a period of investigation. And that investigation will be conducted by a regulator. That could be police if it's of such severity that it is a manslaughter type case, or conversely, if they're acting directly on behalf of the coroner and investigating for him or her. Or it could be another regulator, whether that's the Health and Safety Executive, the CQC, or another. They will likely do the legwork of the investigation and come to a point where they are close to making a decision on whether there should be any further regulatory action. And at that point, the inquest would then take place. And then if there is to be further regulatory action by a regulator, certainly other than the police, then it would happen after an inquest. So that's why we've ordered our session in this way, because in timeline of how things will happen, it's likely to be the regulator that you'll be faced with first. So what is the role of the regulator following an incident? Well, as I said, first and foremost, it's a fact-finding exercise that they need to know what happened and why it happened. They will be accountable to the family to explain to them what happened and to demonstrate that there has been some external scrutiny of the situation. and they will, where there has been a fatality, liaise with the coroner to ensure that he or she has the information they need to hold the inquest. However, alongside that fact-finding role, there are also two other things that they will have in mind. Firstly, they'll be looking to ensure the immediate safety of other service users, staff, and anybody else affected by the incident. So that is those sort of short-term risk mitigation measures that I mentioned earlier, to make sure that both the situation is safe itself. That can be really relevant in circumstances where it's some sort of physical property perhaps that has failed. So if there has been a fall from a window, for example, is that window safe to use? Is the room safe to be reused? It might be about ensuring that your particular policies and processes are changed with immediate effect. So in this case, it could be about instigating new allergy protocols within an organisation, or supervision and observation levels, so that a service user with an allergy isn't left on their own whilst they're eating. And they have got powers to serve enforcement notices to that effect. So particularly the Care Quality Commission and the Health and Safety Executive can serve immediate enforcement notices, which will require you to take that immediate action and in effect say that you cannot continue to operate unless and until you take specific steps that they have identified. Being served with that type of notice isn't in and of itself an offence, but failure to comply with the notice is likely to be a criminal offence. So it's really important that if you get that notice that you comply with it, or you follow the proper channels for challenging it if you feel that it's unworkable for any reason or unreasonable. The CQC, again looking specifically for those of you who are registered with them, also have a power to impose conditions on your registration which may limit the way in which you operate your service. So for example, they may say that you can't admit any new service users for the time being, or that you can only admit service users who fall into a particular category, usually sort of defined by some way of low risk users. Or they may require you to make extra reports to them so that they can understand what you are doing on an ongoing basis. So for example, ask you to review all care records for current service users and provide a report to show that you've done that, undertake audits or specific staff training and provide written reports to show that you have done that. And that's all around ensuring immediate safety so that the operations can continue on a long-term basis, recognising that whether you are dealing with children in an education setting or dependent adults or elderly people in a health and social care setting, that shutting completely is very rarely a viable option, and certainly not an option that will be necessarily in the best interests of your service users. So will only be used if it's absolutely essential because the service is deemed to be such of high risk that it's not possible or practicable to keep it open, even in a limited form. So these other methods can be used to try and increase safety whilst also allowing the service to continue. And then finally, do have powers of law enforcement, both civil sanctions and criminal prosecution. So from a safety perspective, if you are not registered with the CQC, then your relevant regulator is the Health and Safety Executive. So in an education setting, a supported living setting, for example, it would be the HSE that would have this responsibility. If you're registered with the CQC, then they have their own specific powers of enforcement. And that includes criminal prosecution, so needs to be considered really carefully if you find yourself in a position where they say that they are using their regulatory enforcement powers. So what is the worst case scenario in this situation? It is one where you're looking at potential police-led criminal investigation around manslaughter. That could be corporate manslaughter for the organisation and also gross negligence manslaughter for an individual staff member. You could be looking at willful neglect if you are in a care setting. And then you could be looking at the regulatory offences as well that I just mentioned, whether that be HSE or CQC. And I think the important point to make at this point is that although prosecutions and convictions for the offences listed here are still relatively rare, what we see is that the number of investigations that are initiated following incidents is actually much, much higher than the number that find themselves at court. And the impact of being subject to that investigation can be huge, even if you find that ultimately there's a no further action decision. that could take several months or years to get to that point, during which time you've had staff members interviewed under caution by the police, you've had enforcement notices to deal with, you've had service disruption, you've had to account to commissioners and deal with press coverage. It's the process that can be as painful as the outcome. And I think one of the purposes of today's session is just to ensure that you understand how this all fits together, so that if you do find yourself in this situation, you feel well equipped to deal with it, with a view to closing down these sorts of investigations as at early in a stage as you possibly can, to minimise that operational disruption to your organisation, as well as the sort of strictly legal liability point that we would always come back to. So which regulators are involved? I think we've covered this off already, but again, just to make absolutely clear, the suite of those who may be interested. The other one on this slide that we haven't mentioned before is the regulator of social housing. They have a specific role in the supported living sector, but again, don't be surprised if they pop up in this sort of scenario to want to ensure that the service is continuing to operate in a safe and viable manner. The powers and functions of each of these regulators is slightly different. You may find yourself dealing with more than one of them at any one time. I've already alluded to the fact that it may well be the police plus in a fatality situation. If it is the police plus, the police will always take primacy in the initial stages. So in effect, it's the most serious offence goes first, and then others follow behind. You will know, based on each of your own organisations and the scope of what you do, which of those regulators is relevant to you, and what it's worth understanding, at least in very broad terms, what each of their powers are. There are some very common themes in terms of right to enter property, right to take evidence, right to speak to individuals, but there are also some variations which I'm not going to go into for the purposes of this session, because by definition you each only need to know some of them. But if it's something that you need to know, then we can of course help with that, or you can find information on each of the regulators' websites. They have quite a lot of information on there if you wanted to take a look. So in the event of a police-led investigation, it's the offences we've talked about. These processes can, in absolute real terms, take several months to complete. What you normally find is there's a real spike of activity at the beginning, and it feels very urgent, and there's a real sense of hurry to gather immediate evidence, and that can feel quite pressured. And then it'll go quiet, and it can stay quiet for quite some time while the police review the file and it gets sent to the CPS to make a final decision. And that can be a reasonably unnerving period because you don't know what's happening. And it can then pop up again out of the blue. I think an important practical point is if you feel that it's gone quiet for quite some time and you haven't heard, my advice is always that it's better to check than not. I think there's some comfort in thinking, well, no news is good news and I don't really want to know. But if a difficult decision is going to be made and you find yourself subject of proceedings, I tend to take the view that it's better to deal with those head on and to get through the process rather than have it hanging over the organisation for any extended period of time. And of course, you may have individual members of staff who've been spoken to as suspects in that investigation, if it's, for example, the gross negligence manslaughter offence. What we find is that is usually used in relation to people who are very senior in your organisation or the people who are at the shop floor level. So in our case, it's likely to be the support worker who was involved in feeding the meal. You know, what did she do? Is it possible that she somehow deliberately did this? And that's the position that the police have to, by definition, start from, is that we have to consider every possible outcome until we can rule it out. And that does create a real difficulty in that you will get very shop floor level staff who may find themselves being asked to attend an interview under caution on suspicion of gross negligence manslaughter, which is a message I've had to deliver to staff in organisations before, and it's truly horrible to have to tell that to somebody when they don't understand what's going on, how they're involved. Surely all they were doing was their job, and how on earth did it come to this? So the impact on those individual staff members can be huge, and it's really important to think through how practically you can provide support to them, whilst also managing the interests of the organisation, because it's those staff that will keep you going through this period. So from an HSE perspective, so you're in a position where the police aren't interested or that has passed. and it's now the HSE who are looking. So they are considering the Health and Safety at Work Act, which applies to all employees, irrespective of the sector that you operate in. The standard is that you must do everything reasonably practicable to ensure the health and safety of your own employees and others who may be affected by your undertaking. So that includes your staff, any bank or agency staff that you may have working in your organisation or other temporary workers. It includes visitors, it includes service users, and it can include uninvited or unwanted visitors onto your premises, which if you operate a public or semi-public service or a school or a day centre or a community service, then that number of unknown visitors can be really quite high and can be quite a challenge in terms of understanding the risks that they present to you. The standard is a high bar to reach, and in fact there's a reverse burden of proof. So if there's been an incident, it's assumed that something has gone wrong unless and until you as the employer can prove that you did everything that you should to keep people safe. The HSE have got very broad investigatory powers. They're able to take statements, they're able to seize items and documents from your service. Increasingly that can include computers, so literally coming in and picking them up or asking for copies of the hard drive. And they can enter your premises to conduct inspections at any reasonable time. And as I said, they've got both civil and criminal enforcement powers and the power to serve immediate enforcement notices should they need to. And then finally on this section, there are the sector-specific regulators. So I think the main ones for this group are the CQC and Ofsted. And there is a real difference between CQC and Ofsted as things stand currently, in that CQC have got their own enforcement powers, whereas Ofsted much less so. They are more likely in this situation to rely on the Health and Safety Executive to do the safety enforcement work, and Ofsted will follow up behind in terms of the inspection and rating process. But again, CQC has got that power to impose notices and conditions that we talked on, and are able to inspect and rate your service. And it is highly likely that if there has been a specific serious incident, that it will be referenced in the next inspection report that you get, and can, if it's sufficiently serious, trigger an interim inspection, one that you weren't expecting, to follow up on the issues that are of particular concern. So as part of your incident response process, it's really important to bear in mind that you may need to then find yourself being bounced into an unexpected inspection and need to be prepared for that. So what are the key risks in terms of the regulatory process? Well, there are the obvious ones that we've been talking about throughout this little bit of the session in terms of criminal enforcement proceedings and carrying that criminal record. There are also financial consequences, both in terms of a fine, which may be the outcome of a criminal conviction, also legal costs in defending that, but also the sort of commercial costs of dealing with this sort of incident, that you might find that your commissioners lose confidence in the service, so you lose out on placements that you would otherwise have had. And then, of course, the additional operational costs if you find that you are having to make changes to perhaps increase staffing numbers or invest in new equipment to support the service that you hadn't otherwise expected to need. And I can't underestimate the operational interruption that these investigations can have, particularly in those first few weeks. It can be huge. So again, the resource drain on your senior managers in trying to deal with this whilst also keeping the business or the organisation going can be very significant. And I think these sorts of sessions today are giving you a chance to think through in advance how you would deal with a situation, what your incident response processes would be, can hugely help in that sense, that you at least have a sort of a go-to manual that you can pick up and go, right, okay, so the police are coming, what do I need to do? Have a bit of a checklist there to say, right, I need to contact these people, this is where I can get some additional support from, these are the lawyers I need to call, this is my PR agency, this is where I can get some additional staff from. Really helpful. You know, we've done manuals for some clients before where we've gone to literally having sort of precedent press statements in there, letters to families, so just enough to get you started to think, right, how do I find a bit of headspace to know what's going on, whilst also dealing with the emotional and practical side of an incident like this, which again can be really difficult. And So in terms of managing the regulators, what can you do? So moving on from that point around sort of having your own preparedness and having a sort of a bit of a prompt pack ready to help you through this situation. I think trying to maintain control over the investigation for as long as you can is the best that you can do. You're not necessarily going to be able to change the outcome. If the incident has happened, it has happened, and if something has gone wrong pre-incident, then you can mitigate the risk of the impact of that, but you can't turn back the clock. And I think being clear and candid with yourself about that sometimes is very helpful. It's important to recognise the multi-purpose role of the regulators without wanting to sound too much like a cynical lawyer in all of this. I do have, a number of occasions where clients have said to me, oh, it's okay, the regulator's given me some reassurance that they're not really looking at this with their enforcement hat on. It's just to do a few checks, or it's just for the coroner. The regulator is compelled to think of all of their roles when they're investigating an incident. They can't really pick and choose which of those functions they're going to undertake. So they may think that there's not much to worry about and they don't think it's going to end in a particular place, but they can't give that guarantee at the very beginning. So it's really important to keep an open mind. You may find if you've got more than one regulator in place that you're having to help them coordinate to ensure that they're not duplicating or giving you contradictory instructions. So the classic scenario is if you've got the police taking primacy but is sitting in the background, you've got the HSE or the CQC, you may find that you're being asked the same question more than once. And actually, the regulators should be talking to each other and coordinating the information that they have and not giving you double burden in answering those questions. And there's a reason you don't want to answer them twice is because it gives you the responsibility of providing the exact same answer twice, which sounds obvious, but it can be difficult if it's two different people within the organisation who are responding, for instance, or there's been several months past in which you're answering those questions. Yes, of course, there's duty of candour, and it's good to be open and transparent with the regulator, and ultimately they have a power to seize documents and information, so it can't be hidden. But there is a balance. You are absolutely entitled to defend yourself and to wait for the regulator to ask that information of you. So again, it's just keeping that clear head and making sure that you're answering the questions asked of you in the order that they're being asked. And we come back to this point around your staff and your operational duties, that it's the staff that will keep you going through this process. You need an organisation to be existing at the end. You need to keep the relationships good with your staff, with your commissioners, with your service users, and that in itself can be a real challenge, but one that shouldn't be forgotten or underestimated because the impact on everybody can be significant. But they can also really support you if they feel included and involved and wanting to support the organisation, then it can make a big difference. So as a final point, I think it's just about ensuring that you maintain control wherever you can to ensure that the investigation is as measured and as focused as it possibly can be, so that you can get it through both quickly and in as focused a way as you possibly can. So I'm now looking finally at how this all applies to our scenario, just to bring it back to where we started. So it's been a fatal incident, so it's likely that the police will be involved. They will want to know what happened and why, what was the cause of death, consider whether there's any criminal liability in relation to this death, taking it on face value that it's a severe allergic reaction, and if we assume that the individual had a care plan in place which sets out that he had this allergy, then there will be questions around whether or not that care plan was properly understood, how it was being implemented, how the staff had the knowledge and support and training to be able to implement the care plan. Could it be as serious as manslaughter? Possibly, depending on how much was known about the allergy and how far from the recognised standard of care we fell. How bad were we doing is in effect the question that we need to think about. CQC will certainly be interested if we think of their role in terms of ensuring that there is provision of safe care and treatment. Well, on the face of it, this wasn't safe care and treatment. Did we do everything that we reasonably could to provide that safe care and treatment? That's the role of the internal investigation to find out, but it's a real question in this scenario. We'll also need to think about whether or not this was a one-off incident or part of a broader governance concern, so there will be a bit of a backtracking through both the care records for this individual, but also other service users to understand who else has got allergies, how is that being dealt with, how comfortable are we that we've got robust systems in place to protect those individuals. And of course, as I mentioned, it's likely that CQC will consider an early re-inspection of the service to ensure that they properly understand how these risks are being managed. And then, of course, we get to the inquest, which leads us back to where Nicola's going to pick up again to talk you through that part of the process.
Thank you, Anna. So we're going to talk through the inquest investigation, and we're going to cover what the inquest is, the initial stages following the death so far as the coroner is concerned, what an interested person is, the inquest procedure itself, inquests with a jury, evidence and disclosure, what's expected when you have to give oral evidence, the coroner's conclusions, findings of neglect, prevention of future deaths, reports or Regulation 28 reports, the overlap between the inquest and the regulatory process, and then we will offer our conclusions. So going back to basics, what is the inquest? What is the purpose of it? Well, like the regulatory investigation, it's a fact-finding inquiry led by the coroner, and it's held in circumstances where the deceased suffered a violent or an unnatural death, or if the cause of death is unknown, or if the deceased died in state detention, for example in prison, police custody, or someone who is detained under the Mental Health Act, in which case an inquest will be held even if the death was natural and the cause is known. An inquest is a public hearing, sometimes with a jury, to decide who died, how they died, when they died, and where. And families and loved ones often contribute to the process. It's completely different to any other type of court hearing. There's no claimant or prosecution or defence, and only the coroner can decide what evidence to hear. The coroner cannot find anybody criminally responsible for the death. However, if criminality emerges during the inquest, he can pass it on to the Crown Prosecution Service. And similarly, he cannot find anyone liable under civil law, and Tom will talk about that later. These are all issues for other courts to address. But if the regulator hasn't been involved, he can refer it to the regulator at any time, even after the inquest. So why then is the outcome of the inquest so important from your perspective? Well, the coroner can issue a Regulation 28 report, which we'll come on to. The outcome can impact on future claims, and the regulator may respond differently following the coroner's conclusion. And finally, the inquest is an open hearing and the press can be present, and that may generate negative publicity. So what are the initial stages following the death so far as the coroner is concerned, and when and how does he get notified of the death? It's usual that the doctor will report the death to the coroner in circumstances where the cause of death is unknown, or if it's violent or unnatural, or where no doctor is able to complete a death certificate, or there are other concerns about the cause of death. So in Jenny's case, we don't actually know what caused her to die. You might assume it was from the nut allergy, but it could have been that she choked, or she had a head injury when she hit her head on the floor, or maybe she had a heart attack. But let's say that her death was unnatural, so the coroner has been notified. The coroner's staff will make initial inquiries to help to determine whether to investigate the death by talking to the doctor. And if she died of natural causes, such as a heart attack, and there were no unusual circumstances, then there's no need to investigate. That is, unless the death occurred in state detention. And as we've already alluded to, where another organisation or regulatory body is investigating the death, those investigations will be concluded before the inquest, and the outcome of them will assist the coroner. And if there's a criminal investigation, the inquest cannot proceed until it's completed. So if the coroner decides that an inquest investigation is needed, he may ask a pathologist to carry out a post-mortem to help him to determine the cause of death. And again, if this confirms a natural cause and there are no other concerns, the coroner won't investigate further. And he may instruct any other type of expert, usually medical, to help him ascertain the cause. You've probably heard the term interested persons. So what does that mean? An interested person is defined by Section 47 of the Coroners and Justice Act 2009. They include close relatives of the deceased or a personal representative of the deceased. It also includes any person involved with a death who may by act or omission have caused or contributed to the death. A regulator can be an interested person, and anyone else who the coroner thinks has a sufficient interest. So back to Jenny's case, Barbara will most certainly be an interested person, and so will you as the care home manager. Others may include kitchen staff, paramedics, or a hospital doctor, and perhaps the CQC. They may be asked to give evidence by way of a written statement only, or by producing a statement and giving evidence in person at the hearing. If solicitors have been appointed, they will support you and Barbara and any other employees involved throughout the process. And if there is no solicitor representation, the coroner's office will contact you and contact all the interested persons to inform them of their rights and duties and keep them advised as to their hearing dates. And then shortly before the inquest, the interested persons or their representatives will be provided with all of the documentation and evidence that the other parties have given the coroner so that they can see in advance the evidence that will be before the court. And all interested persons have a right to ask questions of other witnesses at the inquest if they wish, and they'll do so through their solicitor if they are represented. So the inquest procedure itself, Anna's already alluded to this, but where an inquest is needed, the coroner will open it as soon as possible, and this is usually a very brief hearing in public where the press can attend. The coroner usually adjourns to a later date so that he can gather all the evidence he needs to enable him to reach his conclusion. But occasionally, everything is already available, so the inquest can be opened, heard, and conclusions reached on the same day. But in more complex cases, or where there are many witnesses, the coroner may direct a pre-inquest review, which is where he will set out how the inquest will run, the main issues to be considered, the documents that will be needed, and what evidence will be heard, and what witnesses and experts will be called. The inquest should take place within 6 months, or as soon as reasonably possible after the death has been reported. And if it's not been conducted by 12 months, the coroner must report it to the chief coroner, giving reasons for the delay. In reality, they often take much longer, and of course, especially now. And then the length of the inquest will really depend upon how complex it is. Most last just a few hours, but the more complicated cases can last several weeks. So most inquests are held without a jury, and the coroner just decides the matters on the facts alone. But in some cases, a jury is called. And that's when public bodies are involved, such as health authorities, special authorities, NHS trusts, regulatory bodies, and local authorities, because they all have a duty to comply with the provisions of Article 2 of the European Extension of Human Rights, and that provides for a right to life. Issues surrounding Article 2 following a death in state care are complex, and Anna will talk more about that in a minute, and a jury is required to decide the cause of death in those cases. These cases are really tricky, and if you find yourself in a situation where Article 2 is being discussed, you should seek specific and urgent advice. A jury will also be called if the death resulted from an accident at work, or if the senior coroner thinks that there is sufficient reason for calling a jury. In these cases, the jury will decide on the facts of the death and answer how the deceased died and the cause of death. So Anna, I'm going to ask you now to talk a little more about Article 2.
Yep, of course. So Article 2 inquests, as Nicola has said, so an ordinary inquest will ask the question of who, when, where and how was the deceased. In the question of how, we mean by what means they died, which is very much the sort of immediate circumstances of their death. So it's the medical cause of death and the immediate circumstances up to that. But in some cases where the state is involved and Article 2 right to life is triggered, there is a broader question asked, and how includes the question of and by what means, and in what circumstances. And what that means is it's a much broader reflection of how the individual came to be in the position that they were when their death occurred, and it will look in much more detail at the circumstances surrounding and leading up to their death, and will look in quite close detail at the care that they were being provided with whilst in state custody. So Article 2 inquests are likely to have more witnesses, more documents, family are more likely to get legal funding, which means that they're more likely to be represented. So the whole process can become more formal and more lengthy. And it's a much broader set of circumstances that are looked at, as I said, and the range of conclusions and comments that can be made in relation to the death are broader. So in effect, there is scope for the coroner to be more critical of the state body that is involved in terms of addressing and understanding the quality of care that was being provided while the individual was within state custody. So Article 2 is invoked when, as Nicola has said, there's a death in state custody, or there is a Mental Health Act detention or pseudo-detention. And in looking at this point, I'm going to pick up one of the questions that's been asked in the Q&A forum, which is great. Thank you for sending that in. And that question is in relation to the impact of having a DOLS, or deprivation of liberty. Is that enough to trigger Article 2? The question is, does it make an impact on the inquest? And Article 2 is the way that it would, but in effect, a DOLS in and of itself is no longer enough to make an inquest necessarily Article 2. What the court will look at is the extent to which an individual is detained because of their DOLS. So if the DOL is quite limited in focus, so it may be that an individual is unable to access the community unless accompanied by a support worker, or they don't have access to particular types of equipment or facilities, then that's unlikely to necessarily be enough to consider them to be detained by the state. Whereas if they have something which in effect means that if the individual wanted to leave the accommodation that they are staying in, if they wanted to leave, they would be stopped, and then steps would be taken to formally detain them, so to section them, then that is far more likely to trigger an Article 2. So Article 2 applies where there is genuine state custody, or in circumstances where the individual would be detained if they attempted to leave. And those situations do arise where somebody, for example, may be a voluntary admission into a mental health unit of a hospital or into an independent provider. But the reality is that had they not volunteered to go into that admission, they would have been detained under the Mental Health Act. That's likely to trigger Article 2, whereas a lesser deprivation of liberty order, which is around sort of the mechanics of how an individual lives their life and the support that they receive, is not sufficient to trigger the Article 2 requirement, and that would remain an ordinary inquest, for want of a better phrase. The final point on this slide, without again getting into too many of the technicalities, I think it's fair to say that Article 2 and neglect in inquest is probably a session in and of itself that can get really quite legal and quite knotty, and is only relevant if it's relevant, so we haven't sought to go into too much detail here. But the exception to the rules set out here by Article 2 is in relation to medical deaths, and by medical deaths we mean an individual who has died as a result of the medical care that's been provided to them, or as a consequence of medical care that's been provided. And it's only where the lack of adequate care is representative of a problem in the system of that care rather than an individual failure. So just because an individual received poor care because an individual clinician made a mistake, that wouldn't trigger Article 2. But if the issue is perhaps because they didn't have access to care, because there was a breakdown in the system as to how different providers worked together, then that might trigger Article 2. But medical deaths would only be treated as Article 2 in exceptional circumstances. So we're looking at something that goes beyond ordinary mistake or negligence in order for it to be an Article 2 death in a medical setting.
Thanks, Anna. So I'm going to talk now about evidence and disclosure in the inquest. So the coroner can require a person to give all evidence to an inquest and or to provide a written statement. They can also ask that somebody produces any document which is relevant to the inquest, or produce any other thing that the coroner may consider relevant. And a failure to comply can result in a fine not exceeding £1,000 and 51 days imprisonment. So in Jenny's case, the coroner is going to want to see the incident report, the investigation report, Jenny's care plan, any risk assessments, and policies that were in place in relation to feeding and allergies, and perhaps Barbara's training records. He's going to want to determine whether the risk assessments, plans and policies were followed. And it's also worth noting at this point the interested persons are able to provide the coroner with any other document that they consider to be relevant. So you've been asked to give evidence at the inquest. So what does that actually involve? In some cases, the coroner is going to ask just for a statement from a witness that will only be read out at the inquest, and he will not want to hear from the maker of the statement at all. So in that case, there's no need for that person to attend the inquest. Others will be required to provide a written statement and to give oral evidence. If you are represented, your solicitor will help you to prepare your witness statement, and this should include your professional qualifications, involvement with the deceased, chronology of care provided, and address any issues that have been identified by the family or the coroner. The family will usually give their evidence first, followed by the other interested persons. And before giving oral evidence, you will be asked to swear on the appropriate holy book or to affirm that the evidence you shall give shall be the truth. If you're represented, your solicitor or barrister may ask questions on your statement, and the coroner will then ask questions of you as well. And then it's the turn of the other parties if they want to ask questions of you to do so. Remember when you were sitting your exams back at school and your teacher told you to read the question very carefully before answering it? Well, the same is true in court. Listen really carefully to the question that's been asked and answer it. Don't stray into other areas and answer other questions inadvertently. Your question should be short, factual, to the point, and directed to the coroner. So once the coroner has heard all of the evidence, the parties can make submissions, and then the coroner will summarise the evidence. He's going to give his conclusion, which was previously known as his verdict, and this is made up of the legal discussion of what happened, the cause of death, and the findings, such as what facts contributed to the death. He needs to answer the name of the deceased, the medical cause of death, the circumstances and the time and place of death, the conclusion as to the death, and the particulars required by the Registrar of Births and Deaths. So that is the date and place of the deceased, the surname, sex, maiden name, date and place of birth of the deceased, and their occupation and usual address. Having heard all of the evidence, the coroner needs to reach his conclusion as to the cause of the death. And he has the option to reach a short form conclusion, which comprises of deaths caused by natural causes, accident or misadventure, alcohol or drug-related deaths, lawful and unlawful killing, road traffic accidents, stillbirth, suicide, or an open verdict, which means that there is insufficient evidence to support any of the other available short form conclusions. However, increasingly, especially in medical cases, coroners are departing from using the wording of the short form conclusions and are creating what are known as narrative verdicts, which are short descriptions of the issues and the findings of fact upon them. As indicated earlier, the inquest must not identify either criminal or civil liability at all, but the coroner can make a finding of neglect, which cannot be a conclusion in itself, but may be added or form part of a narrative conclusion. So in Jenny's case, let's say the coroner concludes, having heard all the evidence, that she suffered an anaphylactic shock, having eaten a nut, and this caused her to collapse. But in so doing, she hit her head, which led to a fatal brain bleed. The coroner is likely to record a narrative conclusion to that effect, because these facts don't fit neatly into the available short form conclusions. So Anna, I'm now going to pass to you to talk a little more about findings of neglect, prevention of future deaths reports, and the overlap between the inquest and regulatory process.
Thanks, Nicola. So in terms of neglect, it's important to note that neglect is not the same as negligence, first and foremost. So they are two different things. They can easily be confused, but for the purposes of an inquest, they are two very separate points. Neglect is not a conclusion in and of itself, but it can be added to a short form conclusion, or it can form part of a narrative. And increasingly we're seeing it being used as part of a narrative rather than added to a short form. So it may well say, it's a factual description to say that the individual died as a result of being fed food that she was allergic to. As a consequence, that she collapsed, and while doing so she bumped her head but the food that she was given was outside of her care plan, and therefore this death was contributed as a result of the neglect of the care provider who provided that food, for example. Thinking of one sort of in fairly loose terms. But neglect is a high standard for the coroner to find. It's not used often, and the reason being that it's only relevant if there has been a gross failure to provide basic medical attention. So that means that the failing has to be more than just ancillary or sort of just below the usual standard. Gross is not defined, but it generally means something that falls so far below the required standard that it should be treated as a serious failing, or reprehensible is a word that is sometimes used in relation to that word, to give an indication of how far below the standard the failure has to be. And it's only in relation to basic medical attention or basic care needs. So in this case, we're talking about the basic requirement to feed the service user. So it's not about failure to provide any sophisticated or additional care. It's about meeting the basic needs of the service user that you are responsible for. So that may be sort of basic medical care that's needed, food and nutrition, safe accommodation, for example, prevention of major harm. As I say, it's not about a failure to provide a specific type of support that may be beneficial or a particular medical treatment that would have been helpful. It's about those basic human needs that we all have. And as it says on the slides there, it's a failure to make simple basic checks. So if somebody requires assistance or observation to keep them safe, so perhaps preventing them from doing self-harm or committing suicide, then if you have got a basic requirement to check that person at regular intervals and that's not done, then that could be something that falls into the realms of what could be neglect. There must also be a clear and direct causal connection between the conduct described as neglect and the death, which must be more than minimally, negligibly or trivially contributed. So there has to be a direct link between what you failed to do and what was the cause of death. So if it's something that you failed to do, but actually in any event the death was caused by a different cause, then that means that neglect is not relevant for these purposes and shouldn't be used. So Regulation 28, PFD, Prevention of Future Death Reports. This is the second role that the coroner has. So in looking at every death, he has to answer those 4 questions that we focused on: the who, when, where and why. But he must also consider whether or not there is a risk of a similar death occurring again in future. And if there is, he or she is required to make a report to identify where he thinks that risk is and to ask the individual or the organisation concerned to explain what they are intending to do about it. So it's about preventing other people from dying in similar circumstances. And the requirement is where there is something which gives rise to a concern that there's a risk of death in the future, and action should be taken to eliminate or reduce that risk. So there must be some action that is in the coroner's mind possible, that he needs to understand if there is something that could be done to prevent an action occurring, and it hasn't yet been done, then he needs the entity to explain what they are intending to do about it. The entity who receives the Regulation 28 report doesn't have to do something about it. What they have to do is respond to the coroner within 56 days to explain their position, and that may be to set out the proposed actions, to explain actions that have already been taken, or to explain the reasons why they think it's not possible for any action to be taken. The coroner himself can't take any action in response to that. So if, for example, you reply and say, we're aware of the risk, but we don't think it's plausible for us to do anything, the coroner can't directly do anything in response to that. But what he could do, of course, is provide that Regulation 28 response to your regulator. So whether that's the CQC or the Health and Safety Executive, and say that he's got concerns and would ask them to investigate. So it is important that if you find yourself subject to a Regulation 28 report, that you respond to it and don't ignore it. This also, I think, ties us back to a point we made earlier around the importance of your internal investigation and identifying the recommendations and the ability to learn lessons. The ideal scenario at an inquest, even if it is a dreadful set of circumstances where you're going in and holding hands up and saying, we got it wrong, we didn't provide good quality care and this could have been prevented, you can at least at that point take control over saying, but this is everything we've done about it, and this is why we're confident that a future death couldn't occur in the same circumstances because we've already eliminated that risk. And that's in a real area of retention where you can make a positive difference even in the most difficult of circumstances, and something that should be given some very careful thought before going into inquest. So just finally, to finish off in this section, to look at the overlap between inquests and regulatory processes. I think we've probably made clear over the last sort of 45 minutes or so that the overlap between inquests and the regulatory process is huge, that you could have one unexpected death that could give rise to a coroner's inquest, a criminal investigation, a civil claim, which Tom's going to come on to, and also concerns from your commissioners. So it's a real spider's web of issues that you have to deal with in that set of circumstances, and one that you will need sort of a real clear head to get on top of and to understand, which again was kind of the focus of today's session. The inquest will not consider all potential liabilities. There may well be separate criminal investigations and civil claims to contend with at the same time, but the inquest is a real pivotal part in that whole process and helps to tie all of the pieces together, and is often the occasion where the evidence is heard in full for the first time, so it can be a real focal point of the whole web. The timing and primacy of investigation is key, as we've looked at in terms of who goes first, in what order and what level of importance. And the regulators can be involved throughout, so they can sit through the inquest, as Nicola has said. And likewise, the coroner can refer matters back to the regulators or the police at any time, even after an inquest, and we have seen some examples of that happening. So it's really important to remain vigilant throughout until you know that all legal and regulatory processes in relation to a particular incident have been completed. So in terms of our conclusions on this section, before we pass over to Tom to talk about claims, is that we're seeing the number of inquests increasing and their complexity is increasing. I think at this particular point in time, we know, given the last 6 months, that there are likely to be a further spike in inquests, and they will be complex, particularly those where it's individuals who've contracted COVID as part of their work, or those who have contracted it in care homes. Then that's likely to be an area of real interest to coroners and something that we will see a lot more of. The key challenges to think about in terms of preparing yourself for those inquests are about keeping good records on a day-to-day basis and making sure that your documentation is in good enough shape that it would support you through this process and not be the thing that trips you up, that you are prepared and ready to take witness statements and documentary evidence if and when an incident happens, and you can respond quickly, so that you can maintain control over the processes as much as you can. And of course, don't overlook the significant role of the inquest. I think, in fairness, I think the days are gone where people would look at the inquest and go, well, it's a court of no blame and therefore there's not really anything for us to worry about. They are increasingly a real forum for scrutiny, and coroners can ask difficult and testing questions. So it's a process that needs to be taken seriously and cautiously. So we're now going to pass to Tom, who's going to run us through the claims angle to the session today.
Thank you. So I've now got the slides, and let me just move to the next one. Right. So I'm going to look at the kinds of claims that could come out of the incident we were looking at. Now, it's very difficult to anticipate precisely what claims could be made, because claimant solicitors are generally fairly inventive, but I can give some ideas and guidance as to what kinds of things could be coming out and the kind of value. So just to recap, the incident was with Jenny with dementia and mobility issues and a very severe peanut allergy, and she needed help with most aspects of her care, especially with eating. And very tragically, Barbara got lunch for Jenny and was helping her with the meal, and 5 minutes later, Jenny began to choke but sadly died in hospital after an ambulance had been called. I mean, it seems to me the easiest claim for a firm of solicitors to bring would be in negligence. I mean, it's clear that the home was aware of the allergy and they were responsible for the administration of the food, and yet did not ensure that the food was free of peanuts. It might not actually be quite as simple as that, though. Who actually prepared the meal? Was it Barbara, or did Barbara just open a packet of food delivered by someone else or prepared by another company, or indeed, was there an outside firm of catering contractors that the home used? So there are some unknowns there, which could mean that it was not actually Barbara who's responsible, and it could be another organisation or company. And we'd have to look at the contractual relationship there with that other company. But then the other side of the coin is whether that outside catering company was made aware of the allergies. I'm assuming that they were, because there's obviously been no previous incident with peanuts. So how did this mistake take place? Was it Barbara's fault? Was it the external contractors, if any? And where does the blame lie? Should Barbara have been responsible for looking at the list of ingredients, for example? So really, as Nicola has been saying in particular, and Anna as well, gathering evidence early on is important. And it's not just taking some statements, it's making sure that you're getting to the real core of the evidence there and thinking about who could ultimately be to blame and who else the claim could be passed on to, and securing things like contracts, notes of orders from the day, and evidence as to what was actually going on and who was responsible for the preparation as well as the provision of the food. But prima facie, it looks like a valid claim against the home. I should also just say in passing that there might be a claim under the Human Rights Act, but most firms of solicitors would concentrate on the negligence one, as it's much simpler. Right, so that's that first slide. Then, now Anna's touched on this, but it becomes quite complicated when you've got a civil claim in the wings, because a claim in negligence will have to be brought relatively quickly. There's a limitation period of 3 years, and if it was a Human Rights Act claim, it would be 1 year. And as we know, criminal investigations, and inquests can all take a long while, so the 3-year period can quickly expire. So you get into quite a difficult position, because if an inquest is proceeding and if there's a criminal investigation and a trial, then claimant solicitors can claim the costs of attending the criminal hearing and of the inquest. And on a relatively modest civil claim, that means that the potential costs that you're being exposed to for the claimant's solicitors attending the criminal trial and the inquest can be very substantial. We're talking about tens of thousands of pounds, possibly up to 100,000. So you have to bear in mind what you do with your tactics. It's easy to say, oh, we'll just stay the civil claim, but you could be sleepwalking into a very large bill of costs. The easiest way to diffuse that risk is to make an admission or make a without prejudice offer and settle the claim. Now, you have to be careful about whether that will have an impact on the inquest, and the coroner can be asked not to take that into consideration or let the jury know about any admission or settlement. But you have to be particularly careful if there's a criminal matter in hand, and take specific advice at that stage, because if you start making admissions, then you could be prejudicing the criminal trial. So the answer to the question, will the claims go ahead now or wait, is it depends on the circumstances and what's taking place. And if it's an inquest and you have a weak defence, then it's probably best to deal with the civil claim as soon as possible, rather than just stay it. So the next question is, how will the claims be handled? It comes back, as so much of this webinar does, about getting the evidence and getting it quickly. As I was saying, you need to be looking at who was actually preparing the food, who the people were employed by who dealt with the food, and also be considering not only whether there's a contractor who might be liable, but also whether the hospital did all they could and whether the ambulance service attended appropriately. It's very difficult to bring a claim against the ambulance service, but these are other issues to bear in mind. So, now, I've just done the wrong one there. Right, what is the likely outcome? Well, I think the most likely outcome is that there will be a successful claim in negligence and that we'll want to make an early admission and offer. There is a very helpful case called James Bowen and the Metropolitan Police from 2018 in the Supreme Court. And that said that an employer owes no duty of care to an employee in the handling of a civil claim. So that means that you don't need to worry legally about Barbara and any settlement that you're making. And even if that means that criticism is made of her, again, there's no duty of care. Now, of course, that's all very well legally, but you'll want to be concerned naturally about Barbara's welfare. So there's no suggestion that you should just be steaming in and dealing with a civil claim, ignoring Barbara. It's good practice to involve Barbara in the decisions and to have her in conference if necessary and to lead her along with the settlement as much as possible. But that case of James Bowen is very significant and helpful. As I said earlier, I think the value of the claim is going to be low. There could be a claim for the estate of the deceased for Jenny's actual experience of the death. Now, her death did take place relatively quickly, but I always think you need to err on the side of generosity. So I'd be looking at a reserve of around £15,000 in respect of that part of the negligence claim. And if Jenny has a husband or wife, then there'd also be a likely claim for a bereavement award, which would currently be £15,120. Because Jenny has dementia, I don't see that there be any dependency claim. So the value of the claim is in the region of £30,000. So my predicted likely outcome is an admission, a payment, and that would then be the end of it. But a payment up to about £30,000. So that's the end of my consideration of the claims. So I now am going to pass the baton on to John. Lou, would you be able to assist with that?
I think we're okay.
You're done. Excellent.
Well passed. Thank you. Thank you, John. And thank you for going out of that. Was very interesting. I noticed we have got a question just come through. I'm just going to park that for the moment, and I'll come to that in about 10 or 15 minutes, if that's okay. Thank you. So yeah, we'll circulate these slides after the event. I should have said at the start. So there's contact details there for Tom, Anna, or Nicola, in case you did want to follow up and ask any specific questions. Okay, so I'm just going to talk a little bit now about the insurance perspective following inquests or regulatory investigations. Before I do that, I'm just going to give a bit of background as to what's going on in the insurance world for the care sector, and then I'm going to drill that down specifically around regulation and inquests. So there's lots of figures bounded about, but as it stands, as a common theme that the projected losses for the insurance industry is in excess of 200 billion following coronavirus and COVID-19. So that's having a huge impact in terms of what's going on in the insurance world. We are starting to see claims come through for employers' liability and public liability off the back of COVID. How easily they are to prove you've contracted unless you're in a sort of care home environment remains to be seen, but no cases have actually gone to court yet as far as I'm aware. So we're starting to see some big impacts there off the back of coronavirus. What that has meant is we're starting to see a move into what we would call a hard market. So for those who aren't aware, we've effectively been in a soft market for the last sort of 17 to 20 years, where quarter on quarter premiums have been reducing, including in the care sector. So commercial insurance has been on the decrease over the last sort of 15 to 20 years. That has taken a swift turn. Premiums are starting to rise. So the main causes of that is as insurers go through their reinsurance treaties and then negotiate with their reinsurers, those reinsurers are taking a big hit themselves due to the magnitude of the losses in the sector. What that means is that they are then charging more for their reinsurance, and then the insurers are having to charge more in terms of premium to appease their shareholders. So we are starting to see, and I'm not going to talk through the whole of this slide, but I will send it through, but we are starting to see some changes. So some of the changes we're starting to see are increases in premium. We're seeing reduction in cover, increased excesses, and I suppose more importantly, especially in the care sector, we've seen insurers either pulling out completely or they're holding patterns. So the number of insurers that are actually playing in the charity and care world has reduced heavily. If you asked me 18 months ago, I'd have said there's probably half a dozen that really played. Now we're probably down to 2 or 3 that are actually actively looking for new clients in that space. So that lack of competitive market means that those underwriters, those insurers can be a bit pickier, and they can look to increase rate, unfortunately, for us guys. So we are starting to see that increase. So just to give an example, this was an email, or sort of an extract from an email that we received from one large insurer, one of the biggest insurers in the world. We got a couple of weeks ago, and this has gone out to every single broker that they do business with, regardless of size. So I've just highlighted some of the areas there, but the main things there that fly out the screen at me is premiums will have a minimum 100% increase. Will also be a reduction in the cover and an increase in excess. So they've kind of gone with a triple whammy of giving you everything you wouldn't want from your insurance renewal. So those changes start to come through big time and thick and fast. And we're seeing it from a lot of insurers, and it's an ever-changing field. So we're seeing that change on a daily and weekly basis. So one insurer might be okay 1 minute, and then the next week they're starting to put big increases in as they go through sort of understanding how COVID has affected their business. So I'm going to bring that back down into sort of how does that work in terms of cover for inquests and for regulation. So I'm just going to talk specifically around some of the areas there. So I suppose the main thing from an risk and insurance perspective is Tom, Nicola and Anna have spoken a lot about the process, what happens. A lot of that will involve a solicitor representation. Also, I suppose one of the key questions is, will the insurer pick up the tab? And the answer is possibly. So I've extracted from 3 insurers that seem to be sort of 3 major players in the charity and care world to extract some of their wording. So I'm not going to read out everything verbatim. If you look at Travellers, for example, they're one of the sort of top 5 insurers in the world. Their wording is probably woolly at best. So it does mention coroner's inquests and it does mention regulation. However, it stipulates it has the company's written consent, and it alludes to the fact that their claim has arisen. So you could be in a situation, and I have had this with clients in the last 12 months with the guys at Beechcroft, funnily enough, where they've been asked to have an investigation or they've been asked into a coroner's inquest, but there isn't any hint of wrongdoing, there isn't a hint of a claim coming from that particular family or service user. So that you're in a bit of a tricky situation. The insurer is waiting for something untoward to come out before they might want to cover you. However, you need the representation at that coroner's inquest or the investigation. So technically they could cover it, but you're in the lap of the gods in terms of that particular claims department of that insurer, unless you get your broker to stipulate something different in your policy wording. If we look at another insurer in ecclesiasticals, these are more education biased. So I know we've got a number of education clients on the call. Again, it stipulates there clearly in respect of any claim. So I think that's the common theme, in that they're looking for a claim to have been presented for them to offer cover. So it's a bit chicken and egg really, because if they don't offer their legal representation to support you and defend yourself effectively or represent you in the coroner's inquest, If that's not done to sort of a correct level, you could end up with a claim coming off the back of it. So we have had to influence insurers to offer cover where they haven't necessarily been willing to. And what you tend to see when you move into a hard market is that whereas in the past insurers would be more lenient and perhaps be more inclined to go with the flow, they tend to follow the letter of their contract much more. So it's very important at the moment to make sure your insurance contract reflects exactly what cover you need and would like. And then we've got a more positive response here. So Markel, one of the leading charity and care insurers, they specifically cover under legal expenses coroner's inquest representation. So it's nice and clear. It's in the wording. They have a clear definition of what's covered. There's a helpline you can speak to straight away and they'll appoint you a panel solicitor. So this is a sort of where you want to end up, where you know you've definitely got the cover. You can call upon your insurer and they'll appoint you a panel solicitor straight away. And ideally, if inquests are something that you're involved in regularly, it's perhaps important to have a regular relationship with the same law firm. So I know, for example, with the guys at Beechcross, they work on a nomination basis with some of the insurers. So you can speak to the same people for all of your inquests. You don't have to explain what you do and how you do it, and you've got a relationship straight away. And sometimes you can pick up the phone directly. So that tends to work pretty well for some of our clients. Again, some of the insurers will cover it under your public liability, others will cover it under legal expenses. So it's important, and if there's a call to action from the insurance perspective, is to have a look or speak to your broker to make sure you've got cover where that cover might be, and certainly make sure you've got that cover from your next renewal. A lot of the time it won't cost you any additional money, it's just sort of confirming that and getting it in writing in the contract to give you that peace of mind. Bit trigger happy there. So I know Anna was talking around fines and investigation. So are you covered for the fine? The simple answer is legally you're not allowed to insure against the fine. In America they're a bit different. You can insure for fines for various things, but in the UK at present you can't. So if you were fined by the HSE or any other regulatory body, you can't cover that can't be covered under insurance. In terms of the investigation, again, it's a similar stance in terms of inquests. So it depends on the severity. If you've had a serious incident and the insurer feels like there could be something coming out of that, can offer sort of legal representation and support with that, or they can offer some of their senior claims guys to help with that investigation and support. Again, it's often not within the policy wording, not specifically covered on that. So it's just something to be aware of. So one of the other factors to consider regarding your insurance is if your insurer covers inquests under the public liability, some insurers are a little bit sneaky and we feel cheeky and will put a reserve against that claim straight away. So you'll have no threat of wrongdoing, no whispers from the family. You've just been pulled into an inquest because your service touched upon this particular service user. And that sort of breadth of people involved has expanded over the last 18 months, 24 months, and more people are involved, even if you've had a sort of minor touch in our experience. What that does mean is you could end up with a claims experience which looks severely worse than it actually is in reality. So we would employ you to push back on those companies or with your broker to knock down those reserves or remove those, because unless there is an intimation of a claim, there certainly shouldn't be a large reserve on there. We've seen that behaviour from some of the large insurers, and it can make a huge difference in your claims position, which can have a huge impact on your renewal. So bearing in mind we're moving into a hard market, you want to be presenting your renewal and your claims experience in the best possible light. So some of you might be sat there thinking, oh no, I'm in a long-term agreement, I'm in a contract, I'm not going to be able to get out of that. If we're speaking candidly, it's very likely that in a long-term agreement or not, that long-term agreement will probably be broken in some way, shape or form for your next renewal, whether that's a premium increase, small, medium or large, or be that a change in cover. So one of the major changes we're seeing at the moment is the COVID exclusion under the public liability. So that is something you should be aware of and look out for. It's something, if you're working in the social care sector, we would advise you to ideally not have that exclusion. Yes, we do think it'd be difficult for any claimant to prove they contracted it if it's not in a residential setting. However, there isn't any precedent at the moment. So until that precedent has been set and until there's been some cases go through the courts, we think it'd be wise to have that option, to have that legal representation and that support in hand. So very much so. At the moment, it's that old adage of looking at price versus quality. So where in the past you might have put insurance at the bottom of the pile, wanted to have the cheapest possible insurance policy, the behaviour from insurers is changing rapidly, and they are going to, as I said, follow the letter of law in their contracts. So it's certainly something that we would advise you to take a look at maybe a little bit earlier than normal, just making sure that there isn't any changes. Don't assume your long-term agreement will be in place come renewal. Don't assume that things like inquests and regulatory investigations are covered. It's likely that you'll see more investigations and more inquests due to COVID, whether valid or not. So we do advise you to take a look at that and make sure you're working closely with your broker to make sure you've got that full protection. So that was sort of a quick whistle-stop tour in terms of what's going on in the insurance world. So hopefully I've answered some of your questions or some of the burning questions. So what we're going to do now is just going to move over to some of the questions. So if we have a look and see, so I think there's one question, but that seems to have been answered. So yes, I think there's one question that's just come through. Can the panel please elaborate on circumstances that may result in a judicial review at inquest and the process involved? So
Want me to take that one?
Yes, if you don't mind.
Yeah, of course. So judicial review applies to inquests where there is a case that the coroner has misapplied the law, and it has to be that he has got the law wrong, not just that you disagree with his judgment of it. So it could be, for example, a case where the coroner has elected to hold a case not under Article 2, and the family of the deceased are arguing that it should have been Article 2. So in those cases I was talking about earlier where there is the sort of pseudo-detention or a dole, and it's not clear to what extent that dole is a true detention or not, then that may be a judicial review. We've seen them before where families have argued that the coroner has misapplied the law on neglect. A lot of coronial law is just set out in case law, so it changes continuously and can get very complex and intricate in terms of how it's applied, which is why judgments change from time to time. If the process does kick in, what would happen is you would have the inquest held in full, the coroner would reach a conclusion, and that would ordinarily be the matter completed. The family would make an application for judicial review as a civil claim to the High Court, which is a claim against the coroner, which in reality is the local authority that the coroner works for, and the hearing would be heard in the High Court initially. If they don't get the result they want, it can be appealed further, eventually up to the Supreme Court. So that's very loosely the application process. It goes into the civil claims system, but as a judicial review claim. So there's a written claim made first of all, then a hearing if permission is granted. They are rare, but if they do happen, they can take several months to come to a conclusion. So coroners will often be very cautious around making judgments that will avoid them getting into judicial review proceedings, which is why sometimes you see coroners being quite conservative in their findings or falling onto the narrative conclusion that we talked about more often than reaching short form, because they're arguably harder to judicial review.
Great, thank you, Anna. We've got another question come through, which is sort of relating more to inquest and investigation. What are the common mistakes during inquest and investigations? I think this is aimed at from a client perspective. What's the sort of common mistakes or any sort of top tips you can offer the delegates here? So perhaps one for Nicola and Anna.
I didn't hear the question properly, John, sorry.
Sorry. So what are the common mistakes made during an inquest or an investigation? So what's the sort of common mistakes that you see or areas that you might be able to offer some top tips to take away on things not to do or to do better or keep an eye out for?
I would just say the key thing is not to be overcritical of yourselves. And I think that's the recurring theme in most things I read, that because a death has taken place, people feel sensitive, they feel that something's been done wrong somewhere, and things said that are unnecessarily incriminatory and unnecessarily self-critical generally. So that would be my overall theme. I'm sure Anna and Nicola will have some more specific examples, but as the person who deals with the civil claims after the event, or as I was saying, probably during the event, you do read things and think, oh dear, why was that said? That was just not needed. It wasn't that bad. It wasn't that appalling. Everyone was, I mean, this is the fundamental thing. Generally, you've got people who are doing their very best in very difficult circumstances, and at the moment even more so under pressure. So just bear that in mind. Everyone is doing their best generally, and there's no need for everyone to be criticised just because very tragically someone has died.
And that comes back to the point. Sorry, Anna. That comes back to my point about leaving emotion and opinion out of the investigation process. It's all well and good to have those thoughts, but don't put them down on paper, because they are your opinion and you might be wrong. We might get expert evidence later down the line which concludes that actually there was no fault, that nothing really did go wrong. It was just the incident couldn't have been avoided. So, like I say, avoid the emotion and make sure that the documentation is really clear and thorough and completed at the time.
From an investigation perspective, I think my couple of bugbears are about keeping control and awareness of that investigation. So I've had a number of cases where if it's a large organisation, we find that there are more than one person corresponding with the regulator, and what we find is that there are two separate conversations being had that aren't always consistent. So you find out that the regulator's been told one thing by one person and actually that's not quite right, or that it is contradictory to what somebody else within the organisation has said. And likewise, if regulators ask for documents or items to be disclosed, that they're handed over before you've had the chance to take a copy or keep a record of what's being disclosed. I've had a few incidents in my time where we don't realise that a regulator's got a particular document, and then you're presented with it perhaps 18 months down the line at an interview under caution or at an inquest stage, and it's really difficult when you don't even know that a particular document exists because you hadn't kept a copy of it, and it's the regulator who's saying to you, well, we know the answer to that question because we've got the document here, and you didn't realise that they had it or that you ever had it in the first place. So you have to disclose most things to the regulator. They've got that statutory power, but ordinarily a copy is more than sufficient, and you should certainly also keep a log of what you disclose to who and when, so that you know what's going backwards and forwards.
Yeah, and I think just to finalise on that question, from my experience, it's important to have the right people looking after the investigation from the client perspective, and ideally people that aren't emotionally invested. So if you've got people that know the service user, have cared for a service user, for example, are they necessarily the right people to be overseeing that investigation? And someone completely impartial within the organisation, perhaps a trustee, perhaps a senior manager, someone who's completely separate from that process and can look at it with a little bit more of an open mind without knowing all the details, sometimes does work better in my experience. Great. There's another question here. I think, Nicola, you're probably best placed to ask this one. So we talked about cases relating to COVID-19. How would it be proved that it was contracted at work? And if so, how would this be possible given that it's a community contracted virus? I suppose it's following on from my point in the insurance section, but what's your sort of legal take on that and where that might land?
So we were never going to escape by not talking about COVID, were we?
No.
A claim in relation to COVID and staff members becoming ill or anything like that is going to be dealt with in the civil court, and it is going to be for the claimant to prove that they contracted the disease in the workplace. In the civil courts, the balance of probability deal with evidence on the basis of the balance of probability. So on the balance of probability, was this virus contracted in the workplace? And it's for the claimant to prove that. And obviously you will respond by saying, well, we had all the processes in place to prevent the spread of the disease. You'll need to prove that you're following the government guidance. So it'd be really important to ascertain what period of time this alleged contraction happened, and what was the guidance at the time, and can you prove that you were following the guidance at the time? And I think that if you can prove that, and that your policies and procedures were in place, then I think there are pretty good grounds to defend the claim. And as John said, these cases haven't really come through the courts yet. We will see them. But I think, again, important to keep your risk assessment up to date, your policies up to date, make sure they're being followed. And then if you can prove that you are doing all the right things, all the government guidance is being followed, then I think you can defend the claim.
Great. Thank you, Nicola. Any more? I think we might have time for one more question before we just sort of summarise and close. Has anyone got any burning questions while we've got the guys on the panel here? Give you a second.
John, there's one I spotted from earlier on about senior staff working from home. I think it was right at the beginning. So the question is, if senior staff are working from home during COVID, can the HSE enter their premises to seize laptops, etc.? It's a good question. I think ordinarily the HSE would have no right to enter a domestic premises. They are only interested in workplaces. But you're absolutely right that we're all using our homes as workplaces in a way that we perhaps never have before. I think in reality it's a point that hasn't yet been fully flushed out in terms of how HSE are expecting us to adapt our workplaces, our homes into workplaces. And it's not just this question that it's relevant to. If you think about all of the standards that would normally apply in a workplace, how do they impose those in people's domestic homes? In this particular question, I think that the reality is that HSE would ask for access to that laptop, and they would place that as the requirement that you, on the organisation, supply the laptop from wherever it is and make that the statutory obligation rather than them being forced to go and seize it for themselves. And my advice certainly would be that if HSE have made clear that they want it, there's very little to be gained by making them go to the extremes of turning up at somebody's home to seize it. You're not going to win in that scenario. If you know that they want it, you are as well to work out how you can sensibly provide it without causing the disruption of them ploughing into somebody's home to go and get it.
Yeah, great. I think just to add on to that point, I think the HSE and regulators probably would be a little bit more lenient the first time round with the first wave of COVID. We've been speaking a lot to clients to say COVID isn't something that's new now. We are aware of it. So things like risk assessments for people working from home, I would expect a judge to expect that to happen if you've got a number of staff working from home, or at least a process to be in place to get that. So it's perhaps something that wasn't at the top of your list when you were in panic mode 3 to 6 months ago. Perhaps is something now that should be on your list of actions to make sure you've got that. I'm starting to see that as a question asked many times, and also around, have you got the insurance for people having kit at home and unoccupied property? So we're going off on a slight tangent, but I think it's areas now where we're coming into a second wave that regulators would expect you to have a plan or a strategy in place. I can't see any more questions. Anna, I think you could see one more than me. So is there anything else I've missed on there? I can't
see one that I was tracking back to. I think that's everything now.
Great. Okay, so I'm just going to spend a couple of moments just to summarise. So thank you very much for listening, everyone. Thank you very much to Tom, Nicola and Anna for taking part. I know a lot of work goes into webinars like this, so there's a lot of work going on behind the scenes, and to Louise and Becky for putting together the technical side of things, so we didn't make any blips there. So just to sort of summarise, I think some of the key elements that I took from that. So try to avoid opinions in your investigation. So whether that's regulatory, whether that's an inquest, I think either way, you're going to have some form of internal investigation. When you do that, make sure you're avoiding opinions and keeping to the facts. And I think Tom's point resonated there. Don't be too self-critical. You might have an opinion on what you should and shouldn't have done, but let's just keep to the facts. What happened? When did it happen? How did it happen? And document it. Investigations can be really overwhelming. We're in a situation at the moment where mental health is probably on the rise in terms of people suffering and people feeling very anxious. So if something like this does occur as well, it's just going to heighten that mental health feeling. So perhaps be aware of that within your staff and make sure you've got protocols in place to support them. I've been involved in a number of investigations or inquests, and the number of times that staff will go off sick as a result of that or during that process is quite staggering. So it's worth understanding and making sure you're checking on people emotionally there. I think there was a point made, I think it was by Anna, in terms of working quickly, so making sure you get these statements, witness statements as soon as possible. People will leave. If regulators get involved and say you can't talk to these people for whatever reason, get a statement there. So ideally in the form of a Section 9, but a written statement, timed and dated and signed would suffice and be useful. So I think those are the key elements, and if you've got any other evidence to support your case, pull that together as soon as possible. I think when we looked in terms of police following up, for example, don't always assume that no news is good news. So do take a proactive approach. If you're being investigated or if there is some questions, perhaps make sure you've got a process in place. You've got someone who's taking charge of that from your point of view to chase people down. Don't always assume just because you haven't heard back that's good news. That isn't always the case, unfortunately. Also, perhaps consider the impact on your organisation, so in terms of resource, relationships between people, potential fines. So there's lots going on in addition to actually going through that process in itself. And it was very interesting to hear the difference between the CQC and Ofsted. So the Ofsted tending to take a bit of a backseat and following the HSE, whereas CQC much more on the front foot. So it's definitely worth bearing in mind. I know some people on this call are more education biased over the sort of care element to it, and others are very much CQC regulated. But there is a massive overlap there between inquests and investigations. So either way, it's worth being aware of that. And so I think overall, having your policies up to date and understanding what might happen and making sure you've got insurance in place and you know what cover you've got should, unfortunately, these situations arise is more important than ever. So those were some of the key points I took from that. I don't know if there's anything else from the panel you wanted to add before we bring things to a close. No, I'm getting some shaking of head. So we've got 3 minutes left. If anyone got any final questions before we give you 3 minutes back in your diaries and we can call the meeting to a close.
Well, John, thanks for doing it so concisely, so we're fitted within the timescale as well.
Look at that, eh? Timing to
yeah.
Brilliant. So thank you very much, everyone. Thanks for dialing in. Do take care. We will circulate the recording of this via email, and we'll also be posting it on our website and then via LinkedIn. So if anyone's got any questions they want to follow up, please do contact myself or any of the guys directly. With that, I shall call the webinar to a close. Many thanks and take care. Bye.
Thanks.